Michael Wainaina Mwaura, who seeks joinder in the capacity of intended respondent or amicus curiae. This court, having looked at the law which we have laid out and principles concerning an amicus brief, we find that the applicant does not meet the criteria set out in law to be amicus, and his application for that fails. However, having looked at the record, we find that the applicant meets the conditions set out in law on joinder to interested parties to a suit, having been a candidate in the just concluded general elections, and has shown a personal stake in the matter. We therefore state that the application is allowed, and we order that the applicants has written submissions to be filed by 8 in the morning by the 28th of August, that is tomorrow. Those submissions should be limited to 5 pages only, of not more than font 12 with 1.5 spacing. The next application is by the intended interested party, Ekuru Alcott. Again, as the court, we have looked at the law. We have found that Mr. Aukot, as a presidential candidate in the election of 8th August, has an identifiable stake in the matter, and he will be directly affected by the outcome of this petition. His application is therefore allowed. He is to file the alleged report in his affidavit by 8 a.m. tomorrow and serve upon all parties. He also must file his written submissions, again limited to 5 pages only, of not more than font 12 and 1.5 line spacing.
This is an application by Counsel Charles Gemma, who is applying to be admitted as an amicus curiae. While admission of an amicus is at the discretion of the court, we note that all parties in the petitions have opposed the admission of the applicant. Mr. Kanjama they have opposed the admission of Mr. Kanjama as an amicus, particularly that he does not possess the expertise he alleges to have, but he is of a general nature, and further, and with particular reference to the petitioners, that he seeks to introduce new issues not advanced by the parties herein.
This is the ruling concerning the application by the Information Communication Technology Association, ICTA, applying to be joined into this petition as amicus curiae. We have looked at the brief. We have looked at the jurisprudence by the court on how one qualifies to be admitted as amicus. We have come to the conclusion that this applicant does not meet that criteria, and in the circumstances, his application is refused. We then have there shall be no orders as to cause on that one. We have the application by the Law Society of Kenya, who also applied to be joined as amicus curiae in this petition. We similarly have looked at their brief, the relevant law, the criteria, and we have come to this conclusion. At the core of this petition is the interpretation and application of Articles 81 and 86 of the Constitution. This places the matter squarely within the society's objectives. In this petition, it's also the question as regards the validity or otherwise of the people's exercise of their sovereign power. We find that nothing can be of great public interest so as to invite the safeguarding from the LSK than a question touching on the people's exercise of their sovereign power. Consequently, we find and hold that the LSK has made a case for its admission as amicus curiae in this matter. As the court reserves the right to direct the amicus on how to proceed, we direct that the LSK restricts its submissions on the single issue contained in its brief, particularly the rightful interpretation of Section 83 of the Elections Act in relation to of the Constitution 2010. The application is therefore allowed.
I have before me the application made by the Honorable the Attorney General, also to be admitted in this petition as amicus curiae. The Attorney General wishes to assist the court on several issues. We notice that quite a number of issues that the Attorney General wishes to address us on are already covered by counsel who are appearing in this matter. So in the circumstances, we allow the Attorney General to appear as amicus curiae, but limit him only to one issue, the application, the issue of what was the effect of the jurisprudence enunciated by the Court of Appeal in the case of IBC versus Minor Kiai and others. So the Attorney General's application is allowed, but is limited to that issue only. Thank you. We have one application which we were unable to complete. We will deliver it first thing tomorrow morning at 9 o'clock. Immediately after delivering that ruling, that is the ruling by the petitioner on access. There are quite a number of issues that we would consider, so we'll deliver it tomorrow morning at 9 o'clock before we start the hearing. Immediately after the delivery of that ruling, we shall commence the hearing. That's it. That's it for tonight. Thank you very much.
That's fair. Now, so we've got 1.5 hours.